Yeah, if anything, it might be closer to 2.5, but based on how long the motions to quash take was a little unpredictable for me, that's why I said 3.
Okay, and my inclination is when the potential jurors come up, the veneer comes up, that we tell them just to be safe that it's going to be 4 days. And my thinking with that is that gives us all 3 days, today, tomorrow, and Thursday, to complete the trial itself, and then deliberations if they need to spill into Friday. That way we just make sure that we get enough people who can definitely serve throughout the trial. Does that sound like a good plan to everyone? Yeah. Okay, that's what I'll plan on doing. Anything that we should probably address before the motions to quash, or does it make sense to move on to those next? All right, let's move on to those next. I have one from G4S. Is an attorney from G4S here?
I am, Your Honor.
Hi.
Good morning, Chris Hawk for G4S.
Okay, great. And I have your motion to quash. I've read it. I think I understand what the issues are. And then let me just make sure that I'm understanding the request from the defense. It's G4S policy documents regarding use of force for employees providing security at Portland City Hall on January 9th, 2019. And I think you said Mr. Hawk, is that right?
It is.
All right, anything that you want to add to the written motion?
I don't believe so, unless you have any questions.
All right, not yet. Let's go ahead and hear from Mr. Gilbert. Anything that you would like to say in response to the motion to quash?
Yeah, thank you, Judge. So just a little bit of background. I'm not sure how familiar you are with the facts, but this is regarding an incident that happened July 9th at City Hall here in Portland. Mr. Davis was at a council meeting. He was ejected. In the process of being ejected, there was some sort of physical interaction between Mr. Davis and the security there, security which is provided by G4S. Mr. Davis was injured, I believe it was to his hand. He received a scratch or a cut, and there was bleeding. He would justify several puncture wounds. And there's also an allegation of criminal mischief based on actions that are alleged that Mr. Davis took that involved that blood. So we're asking for the use of force policy to know what the employees that Mr. Davis was interacting with that day, what they were required or advised to do in that particular date and time. And I do think this is relevant. Not only was he injured by their use of force, but they would also be useful for impeaching any testimony of anyone regarding anything about the appropriate level of force in the process of having Mr. Davis ejected from the premises.
And let me just sort of flesh that out a little bit more. So the use of force that the security agency used is relevant to the charges here because of potential for bias of the witnesses who are testifying. I'm not making the connection.
Because I was injured and there was a use of force, and there's a former trial where use of force was used on me by Kif Davis, where a security guard tackled me, and they released that use of force policy if we were going to go to trial. And G4S argued against it before the judge said, no, you used force on Mr. Davis, so you have to present your use of force if you're going to trial. And I'm kind of expecting the same thing today, since they used use of force and they even escalated their level of force to physically attacking me, and the guy just dug his claws straight into my hand and punctured my hand in several places.
I think I understand all of that, but tell me how that is relevant to the elements of the offenses or any defense that you're raising.
So if the use of force that was actually used that day is not consistent with their use of force policy, that would be helpful to establishing bias. It would tend to show that there was something more going on
I was
that caused
also
them to not
threatened
follow.
by G4S before the meeting started.
Can
They
I
said,
finish?
Yeah, and just a few ground rules, Mr. Davis. It's important not to interrupt people in court when they're talking, especially your own attorney. If you have something that you need him to know, make sure that you just give his attention at the appropriate time or write him a note. But
Yeah.
it's difficult when you interrupt because it disrupts the proceedings and also makes it difficult for us to do the recording when people are talking over each other.
And I also lose my train of thought sometimes. Every time that happens, and you just kind of have to keep going. Hope you get back there. But I do think that if the use of force policy was, or the use of force that day was not consistent with what's in the policy, that would tend to show bias. It would tend to show that they went above and beyond in what they did because of some other reason, which I would argue was because of who Mr. Davis is and what he represents to City Hall or to G4S.
Okay. And do you have specific reason to believe that the use of force during the incident was inconsistent with something in their policy materials?
Just 1 second.
Sure.
Okay. So the way the use of force is, the use of force that day was described to me as, kind of digging into Mr. Davis's hand, sort of like a clawing, which doesn't seem to be any kind of tactic, any like pain-inducing tactic or anything like that. It seems to be the kind of thing somebody would do out of anger and not persistent to some consistent policy. So based on sort of general familiarity with other use of force policies and common sense, I think that it would be inconsistent with the way the use of force that day has been described to me.
Okay. So I want to make sure that I'm understanding the argument exactly. So it sounds like the materials in the use of force policy could be relevant if a witness from GS or G4S testifies in a manner that is inconsistent with the policy.
Well, that statement is true, but that's not exactly what I'm saying. Because another way that we could establish the force that used that day is through Mr. Davis's own testimony, testifying about what happened to him, what steps led up to it, as well as what may or may not be visible on the video.
But couldn't that be addressed by asking the G4S witnesses, assuming for the sake of argument that Mr. Davis's account is true, would that be consistent or inconsistent with your policy?
That might be one roundabout way to get to the same result if they were honest and they provided, if they were familiar with it, if they had it with them, or in some way that they could testify to that. But we don't have those people subpoenaed. I do think the state has subpoenaed some of those witnesses.
can I say something?
Well, Mr. Davis, the thing is that you have an attorney. You've decided to go forward with an attorney, so it needs to be through
I'm
Mr.
trying to
Davis.
let him, but, we're gonna
I'll let you talk in a minute.
the level of force that is higher than working police bureau. There, you can, and this is something that if these guys are getting $10 million contract through City Hall, that this should be on public record, their use of force, just like the police's use of force. What are they hiding? Like, who are these people? They're a foreign mercenary firm. They're a former Wackenhut, hired Dick Cheney, and they're supposed to be an
Judge.
honorable corporation.
Okay.
I'm sorry, this This is the whistleblower.
Okay.
You guys
Okay,
have
can I just finish? Okay. So, I do think the documents, if they were provided, would provide relevant, admissible information for impeachment, if nothing else. I don't think that the burden of producing this would outweigh any interest in the difficulty providing it. I think if there was any concern about proprietary nature of those things that can be addressed by protective order, I just don't see, given the fact that this is a trial subpoena, not a pretrial subpoena, since I think it's clear that there is potential use for trial, and I think that's all that's required under state regs to order their production.
Mr. Hawk?
Thank you, Your Honor. Excuse me. I think your probing questions were on point. The issue is not about whether, again, at this trial, the issue is not what G4S did for force. This is criminal trespass, criminal mischief case. This has nothing to do with G4S's actions that day. They haven't met their burden to show why they're going to do this. They have to do more than just think of some hypothetical situation that, even if it's true that they're talking about, doesn't help or hurt their defense, doesn't move their defense in any way. Showing, I'm not exactly clear how there would be bias, how they would show the bias, but even if they had that, I don't know how that would help move their case one way or the other concerning the criminal trespass, criminal mischief. The document is just, it has nothing to do with this case, and their use of force policy is simply irrelevant. And I think that was your point you were trying to elicit from them was, well, what are you going to use it for? And they haven't been able to articulate a good, compelling reason. And there has to be one to trial, for a trial subpoena for those documents to come in. So that's our position.
All right, thank you, Mr. Hawk.
Thank you.
I understand the arguments of both sides. I'm going to grant the motion to quash. I understand Mr. Gilbert's argument about how these materials possibly, hypothetically, could be relevant to impeaching witnesses from G4S who testify. However, I think something more than that is required. At this point, the relevance of those documents depends on a series of events happening in just a certain way at trial, such that G4S witness is called to testify. A G4S witness testifies in a manner that is potentially inconsistent with the policy materials, and then refuses to admit that on cross-examination. All of those are a series of events that would need to happen in order to trigger the potential relevance of the documents. Because of so many links in that chain, I think the use of these materials is too speculative, which is exactly what the case law identifies as a basis for a motion to quash like this. So the motion to quash is great. The next motion to quash is from the city of Portland, and it is with respect to subpoenas for emails, as I understand it, and the motion also indicated that it was the city's belief that the people themselves, the city council themselves, were also subpoenaed to testify. Is that correct? And I'll have you go ahead and place your appearance on the record. Sorry.
Thank you, Your Honor. My name is Robert Taylor with the City Attorney's Office. And that was our understanding of Mr. Gilbert's intent with the subpoenas, was to have the elected leaders appear here with the emails. It's not clear to us the purpose of that. We do not believe that it is, that they can make a showing that there is any reasonable likelihood that any of the testimony or the emails are material or favorable to the defense. So that's the basis for the motion to quash. The other, there's availability issues. Three of the members of council just aren't in town at all. There's only two that are even remotely available, and that's on a limited basis. And then finally, any evidence that the mayor or Commissioner Hardesty could give would be cumulative of all the other video and eyewitness testimony. So there's no need to drag two of the highest elected officials in the city in here to testify on cumulative